overlapping symptoms of the mental illness or the substance abuse. Can't say by the preponderance of the evidence that it's unrelated. The substance abuse treatment clearly began long before any symptoms that they've described for me of the mental illness that they're diagnosing. In fairness, Dr. Danziger met with her, I believe, one time. Dr. Fabian met with her 3 times. And a lot of their information was based on her self-reporting. In addition to that, the state made the point across that when I'm looking at the language that requires specialized treatment, well, part of that specialized treatment was a mood stabilizer, which I think was pretty much conceded could be provided in the prison system. So I can't say by the preponderance of the evidence that the grounds for the downward departure have been met. Had I found that, though, I do want to go ahead and say, answer the question of whether the court should depart. Even had the court found that the downward departure was met, this court can't say that this is the case where it should depart. The facts of this case are fairly egregious. The defendant admits to drinking vodka before driving in her kitchen while she's preparing, I guess, burritos. Her blood alcohol is very, very high. Though low level, she has some THC in her system. There's an open bottle in the front seat of the car of the vodka that she's drinking, apparently. She runs a red light just prior to this accident, almost causes another accident, slams into the back of this decedent, Mr. Lassiter, so hard that he hits the car in front of him. While he's stopping at a red light at, before 8:30 p.m. in the evening. So through no fault of his own, and I can't say that I've seen anything that Mr. Lassiter could have done to prevent this. Unfortunately, we had the death of Mr. Lassiter. In mitigation, I do have to acknowledge a few things. While I don't feel that there are grounds to downward depart, I think there was some evidence of at least some current mental health issues in regard to the defendant, some serious addiction issues. She has had some tragedy in her life, although candidly many of us have, and unfortunately it doesn't really relieve the responsibility of a crime like this. The defendant in this case has entered an open plea. She's taken some responsibility for her actions, and I do credit her for that. In regard to the Gabriel case, and I'm going to go ahead and cite the case for the record. It's a Supreme Court case from the state of Florida. It is cited at 314 7th 3rd 1243. It's a 2021 case, as I said, out of the Supreme Court of Florida. State's arguments in their memorandum of sentencing is that because that's her maximum, that is also her minimum pursuant to the Gabriel case. I don't see any other way that you could read the Gabriel case, and I think, in fairness, the defense has sort of acknowledged that that's pretty much the situation. So, in regards to counts 3, 4, 5, 6, 7, and 8, is that accurate? The misdemeanors pursuant to the negotiations and adjudicate the defendant guilty, sentence her to 364 days concurrent with any other counts in this case, with credit for the 364 days that she's already served. She's actually got more credit than that, but that's the statutory maximum. In regard to count 2, driving under a suspended license, causing death or serious bodily injury, I do note it is an aggravator that she had no valid license, and she's not only choosing to drive, but choosing to drive under the influence. Pursuant to this, and state, not to be nitpicky, but I actually come up with the amount of 10.6625 would be the minimum and the maximum. So just to clarify specifically in calculating, I'm going to adjudicate the defendant guilty, sentence her 10.6625 years in the Department of Corrections. Her credit is 566 days, so with credit for the 566 days. On count 1, the DUI manslaughter, second-degree felony, I'm going to adjudicate you guilty. I'm going to sentence you consecutively to 7 years in the Department of Corrections, so to be served after the 10.6625. With, again, credit for, well, she's already gotten credit, I guess, on count too, so that would already be applied. In regard to the remaining 8 years, I'm going to sentence you to followed by 8 years of probation, the conditions of which are following. Let me see where I put those down. There is a 4-year minimum mandatory to count one, so the first 4 years of that term will be a minimum mandatory sentence. Conditions will be standard conditions of probation, plus she must have a substance abuse evaluation with any follow-up treatment. She must have the alcohol safety education course. If that overlaps with the substance abuse evaluation, of course, there would only be one required. Victim awareness program, 50 community service hours, $10,000 fine, and her driver's license will be permanently revoked. Otherwise, any standard fines and costs. State is not requesting cost of prosecution, cost of investigation, so I'll not be applying them. All right, does that cover everything? State?
And ounce of information.
All right. Any questions, Ms. Sytch? All right. You have 30 days to appeal. That must be in writing with the clerk of court. If you cannot afford counsel, appoint counsel to represent.
Yeah, let's go.
All right.
Maybe we can appoint for purposes of appeal now.
Can we go ahead and put that?
Thank you.
All right. Court's in recess.